Hey everyone, and welcome to another episode of Exponential Wealth. I'm your host, Aaron Moore. Today, we have a very special guest. And before I even let you know who that special guest is, I want to talk to you quickly about some really important things that we're going to cover today. All right. So for those who have been listening since the beginning, our podcast is aimed at reaching you who is looking to build wealth in your life, protect your wealth, and pass it on, those lessons and that wealth, to your children and to the next generation. So today's guest, I couldn't be more thrilled to share with you, because she is going to give you some of the tools and some of the things that you need to do today to protect yourself and your legacy and your family. All right. So here's the deal. We have so much all around us, inundating us with news, with information, pulling us this way and that, right? There is so much in the world out of our control. We have the markets. We have no control over that. We have inflation. We have no control over that. Who's in Congress? Who's in the White House? We can vote, sure, but the outcomes, the policies that they implement, those are all out of our control. We have a vote, and then it's out of our hands. Representative democracy, all right? What we're talking about here today on this show is things in your power that you can do today to protect yourself and to protect your family and to protect your legacy. All right. So I get up every day, and hopefully you don't do this, and check the stock market, check how my portfolio is doing. What's my real estate doing? What are my stocks doing? What are bonds doing? What is this doing? That doing? All right. All of those things can lead us to feeling of anxiety, feeling of inaction. We don't have control over those things. All right. What do we do have control over? We can make decisions every day to make our life better. And what we're going to be talking about today is exactly what we can do to make that happen. All right. So without further ado, for the second time on our podcast, Miss Stefani Coggins, attorney at law, estate planning attorney. Stefani, I can't think of anyone better to have back on the show to talk about the things that are important to us. And so we're going to be diving into those again. The last time that we talked about all the different parts of the estate plan, the trust, the will, the powers of attorney, avoiding probate, right? So if you want to learn more about why you need to trust in those basics, then you need to listen to our first episode where we dive into those. It's worth the 30 minutes. Today, we're going to go a little bit deeper into some case studies to give you some ideas of specifics of when estate planning is not needed, it is required. All right. So Stefani, thank you so much for being on today's show. How you doing today?
Doing fantastic. Excited to be here again.
That's great. We're excited to have you back again. What's changed since the last time that we were on? Real quick, any new laws, updates, and legislation that we need to be aware of? Any changes? And it's okay if the answer is no.
Nothing for the current time, but we're getting numbers out for next year's estate planning exemption and tax figures. So that's exciting news for next year's tax planning, but nothing right now.
All right. So that's a great way. That's a great way to get our heads around this. So if you are paying estate tax, what does that mean? How much are you, when you pay estate tax, what's the upper limit on wealth when you're transferring?
For California residents, we're concerned about federal estate tax exemption. Currently, this year's figures is $12.06 million per person in exemption. So only if you're over that amount are you looking at paying taxes, or your kids paying taxes when they inherit your estate. Because of inflation, that number is indexed for inflation. So next year, it's looking to be about roughly 12.9 million per person, which is, I believe, the biggest jump in exemption indexed for inflation that we've had so far.
Right. And that's per person, right? If you're a married couple, each can pass 12.9, right? So that's almost $26,000 short of that to pass down between a married couple. That's incredible. May we all be so economically fortunate.
26 million is huge.
Yeah, 26 million, right? All right. So there you have it, folks. there's your hurdle to reach over. So as long as you're below 26 million, you can pass all that along to your children without paying an estate tax. And Stephanie, a lot of what I want to talk to you today is about what happens between passing assets. And specifically, I want to talk to you about real estate, because that seems to be the number one asset that people own and becomes in play when you're, when one family member is reaching the end of life and they're thinking about how they want to pass this asset on to the next generation. All right. So, and that's all we're going to go to. So I want to talk about real estate and I want to talk about estate plans. So let me throw you this first example that I want to go over with you today. So we have a client right now that we are trying to equalize the benefit of this home to both the son and the daughter of a surviving spouse. She already lost her husband. Unfortunately, it's an elderly woman living in the home, has a son, has a daughter. Well, guess what? The son is currently living in the home now with his mom. And by the way, the son and the daughter are grown-ups, right? They're grown. They're not children, right? They're fully adults with their own kids. So the woman's a grandmother living in the house, just so you have some context here. The son wants to continue living in the house. The daughter does not live in the house, doesn't want to live in the house, would look to want to sell the house. So they need to share this asset. And by the way, there's no other accounts. There's no stocks or bonds or life insurance that would come into play in the trust. What can estate planning do for this son and daughter to equalize the estate once the grandmother, the mother that's living in the home, passes?
Great question. So I see this scenario pretty often, actually. So while mom is still alive, she's got some planning options that she can do in advance to help prevent any fighting between the kids after she's gone. Ideally, to help equalize the inheritance between the two kids, if she can qualify for life insurance, that is the great equalizer at the end of the day. That's an influx of cash into the estate that we can use to provide the house with the mortgage to the son who's living in it still and he wants to keep it. And life insurance proceeds can equalize cash distribution to the daughter, making sure that all around everyone gets 50-50, but they get what they want of assets constituting that 50-50. So that's the ideal scenario. If she can qualify for life insurance, we want to get a good policy going with an amount sufficient to cover the costs of administration when she's gone. And then that equalization between the two kids. Unfortunately, some individuals, when they get to the point of making these decisions, can no longer qualify for life insurance. So what else can we do? We can do estate planning. Have a revocable living trust that puts instructions in place for what the mom wants to happen with the assets for the kids later on. So options include providing occupancy rights to the son to continue to live in the residence for a period of time, allow him time to kind of get life situated after mom is gone, find a new residence, a new place. If mom decides that at the end of the day, the house should just be liquidated, sold, and the cash proceeds split. Or mom can provide, lifetime occupancy rights to the son. As long as he wants to live in it and maintain it, then he can do so. We can figure out payment of rent to sibling if mom wants to put those instructions in there. How maintenance and costs are going to be handled between the two siblings, the one who's living in versus the one who may not see their inheritance benefit for a while. So there's a lot of instructions that mom can leave in advance to help quell future disagreements between the two kids after she's gone, after the referee is gone. And then we also see those circumstances where the parents didn't think about this prior to death and didn't put any planning or instructions in place. And now mom and dad are both gone. and the siblings, brother and sister, are looking to, what do we do? How do we help brother with his circumstances while still getting sister, or son and daughter, however you want to look at it, while getting the daughter the inheritance benefit without having to wait around forever to be able to get her cash and do what she wants to do with her inheritance. Right. So it's more complex at that point. What you're looking at doing is, if you're trying to preserve property tax basis and keep your property taxes low, you're looking at, financing the property within the trust vehicle so that we can pull cash out of the equity in the home, so that we can pay daughter her portion of the inheritance. We can distribute son's portion of the inheritance, the net value of the house, to him with the mortgage on it that we financed during the trust administration. But in order to do this so that the assessor's office agrees and allows you to keep a low property tax payment on it, still inheriting that property tax from mom or dad, you have to get a hard money lender involved. A lot of traditional lenders don't lend to irrevocable trusts and trust administrations. So you have to get a hard money lender in there. The costs and fees are a little bit more. It's a short-term loan to be able to pull equity out, give cash to daughter, give the net value of the home to son. And then the real trick and the real key here is that at the end of the day, once you've made those distributions, son then really needs to be able to qualify for a traditional loan on his own to refinance out of the hard money loan, get that paid off and off the table. Then you have a traditional loan for son with the net value of the property. He has the property, he has the loan payments going forward. And it helps to keep the siblings from having to go into business together, some would say, as far as keeping the home with son living in it, paying rent to a sister. That can get tricky often. And
it's especially tricky, Stephanie. I mean, you just laid out all these scenarios. So I hope if you're listening, you really took notes. You can rewind and listen to that. I think you just dropped. I think lawyers might charge an hourly fee for what you just shared for free. So I really appreciate you sharing that with us. The challenge, which you've just described about getting a hard money loan, the challenge here in this particular case, and a lot of people are going to have this challenge going forward, you have inequality with the siblings, right? In this case, it's the daughter who works, who can afford the mortgage, right? Isn't necessarily needing the cash on hand, but could really use it to pay for her children's college coming up and funding her retirement, right? And the son in this scenario, who doesn't really work, was a caretaker to the mom, won't be able to qualify for a loan on his own and is going to be housing insecure afterwards. It really puts these two in a tough situation. And they're really going to need, Stephanie, they're really going to need some, in this example, some counseling and financial planning to figure out, hey, well, can the daughter essentially float the son while he lives in this house? Could he pay rent? Would that be enough? And then she gets the asset later on. So it's really a tough question. We're not going to answer it today. So if you're looking for an answer for us, folks, we're not going to give it to you. This is all about the personal preferences and wishes of the family in this situation. Sounds like they got a tough decision to make, Stephanie.
Exactly. It's definitely more difficult when a child is not going to be able to qualify for a traditional mortgage, so you can't really use that hard money loan to equalize it out. So it's something where if you can plan for that in advance, if mom and dad can put instructions in place in advance, if you know this is going to happen between your kids, get with your estate planning attorney, get with your financial advisor, see if you can get some liquidity in the estate with life insurance. If not, make sure your estate planning documents are updated to give clear instructions between your kids as to what you intend to happen with the family home, how you would like to see it done, And unfortunately, if you're in the circumstance where your parents have passed and you're dealing with your sibling with the family home in this situation, instructions weren't given, you need to get with your financial advisor. You need to get with a trust administration attorney or a probate attorney to make sure that everything is clearly spelled out between the siblings as to what's going to happen. What are we going to agree on? If we're going to keep the home, we want a clear set of instructions so that people don't, get animosity building and later on down the road, there's a big fight over it. You want to set it up in advance. This is how it's going to be handled. Here's how we're going to move forward so that it takes a difficult situation and it eases the burdens a little bit on both sides.
That's right. And in situations like that, I will meet with the brother and the sister. We might have to do some financial planning for the brother in this case, right? So you take half the proceeds for the home and say, hey, you have insecure unemployment. It's not like you have income coming in, or else you would have qualified for the refinance and you could have stayed in the home. Makes it particularly challenging being here in the Bay Area. You could sell the home for more than it's worth when it was purchased, right? You'll get if it's titled properly, you'll get a step up when the mom dies, right? If it goes to the kids. And then, we as financial planners can determine, well, with this lump sum from the house, how do we design an income stream, a pension-like producing asset that can provide you with steady monies for rent so that you can take care of yourself. But again, we're not going to solve it today, Stephanie. This is about how willing you are to take care of your sibling for the rest of your life. But it's a huge gap, right? Between here where the mom's alive and we have the sibling in the house, and here is the dream state where here's where you need to be, which is the home is sold, the assets are split, and the brother is taken care of forever. This is a huge gap that we need to fill. So, but the idea today, Stephanie, I think, is that when people are listening to this, getting the idea of, hey, we got to get creative with how we can solve this problem. What are our options? And let's engage with the professionals, the advisor and the estate planning attorney, and come up with a plan. All right. So before I pull any more hair out over this, because I'm getting anxious just thinking about how we're going to solve that problem, I'm going to throw you a new scenario. All right. Because that's just one of many scenarios, right? Where you have inequality, right? Between the siblings, and maybe one has to take care of the other. So let's transition to this next scenario. It's another client, very fascinating. And I think, this will be a little bit more enjoyable process to design, right? A plan to design. So what we want to do here in this next scenario with these clients, we're looking to balance the desire for, here we have an older gentleman who has a son. He's grown. He has one child, and he, divorced when the kids were young. So none of the home is going to the ex-wife. It's going entirely to the son. Unconventional man that lives in the house who is not married, but has a girlfriend. They don't have domestic partnership status, which is similar to a marriage. You go to the court. Stephanie, jump in if I'm incorrect here. But domestic partnership is still a legally binding document, and you need to go to the courthouse and get that complete. Let me stop there.
For a domestic partnership to be considered a registered domestic partnership with similar rights and duties and obligations as a marriage, you need to register it with the legal offices in the state of California. So if you're a domestic partner, the question is, are you registered domestic partnership, or are you just partners? And life partners is fantastic, and that's fine. And we work with life partners, but it's a big difference in rights and duties and obligations between a life partner and a registered domestic partnership.
Thank you. So you can't just say, oh, it's my domestic partner. Those are just words until you get the thing notarized and get it in with the proper authorities. So here's the scenario, right? So you have the father living in the house. He's got the girlfriend. The girlfriend keeps her own place but he wants to provide, she's younger, he wants to provide a place for her to age, right? And for her to live. But they don't have any kids together. But he does. He wants the asset. He wants the home to go to his son. So what are some things that they need to be considering strategy wise now? They don't have any planning in place, no estate plan. The dad's on title. That's it. That's all we got.
This is a fantastic case for planning in advance, making sure your wishes and instructions and intent are put into instructions for your partner and your kids to ensure that everyone knows right at the get-go what's going to happen, what you want. And maybe they'll have to wait for their inheritance, but this is what your instructions are. So you want to absolutely get with your estate planning attorney. And in this scenario, you've got a good option to provide occupancy rights to your partner, your girlfriend, your boyfriend, whoever it may be. You want to put instructions in your trust that says, look, I want my partner to continue to live in the residence rent-free. How are expenses going to be paid? Who's going to maintain insurance, property taxes? If there's going to be improvements to the property, capital improvements can be really expensive. And yes, it benefits the partner who's living in the property, but capital improvements also benefit the future child's inheritance when he or she gets the property and is able to liquidate it or keep it for himself. So you want to put those instructions in place. You're going to say, live there rent free or pay rent. You're going to say, maintenance, insurance, taxes, expenses are to be paid by partner, split between partner and child. Capital improvements, maybe you put a dollar amount in there. Under this amount, my partner pays it because she's living in the property. She's benefiting from current use. Over this amount, it's split between my partner and my son because he will eventually see the benefit of having a new roof on the property when he inherits it. And then, is your partner allowed to rent it out? Can your partner move out and rent out the property? We've got a lot of Airbnb or VRBO rentals, right? Can you allow short-term rentals? Or do you just want to put restrictions? Your partner can have blood relatives move in with her, right? Have a sister, if sister's in need, move in with her, but no one else can move into the property. Right. Can't rent the property. Can the partner encumber the property? Can the partner take out a loan on the property? And then all of a sudden partner passes and your son's responsible for that loan. You want to think about putting maybe restrictions on that. And then at what point in time does the occupancy right terminate so that your son's inheritance does not get held up forever, right? If your partner can no longer live in the residence as her primary residence anymore, if she's in a care facility and not expected to return home, when she passes away, that occupancy right needs to have a termination trigger for it. So it terminates, the interest then goes down to your son who gets the ultimate inheritance of the property. And he's allowed to do whatever he wants with it then. He can sell it, he can keep it, rent it out himself. You don't have the same restrictions for him, or you could. It's your instructions. But as you can imagine, that's a lot that people don't usually think about needing to cover. It's like, no, I want my partner to be able to live in it, right? Yes. Fortunately, from a legal perspective, there's a whole lot more issues you need to talk about and you need to lay out to make sure, again, the goal is to minimize tensions between future inheriting parties. So minimize tension between your partner and your child, because one person's getting a really great current benefit and your child's having to wait for potentially a long time to see their inheritance later on. So I want to minimize that.
Stephanie, like everything that you just said, right? Just up here, mind blowing in the sense that you never think about those things, right? You're like, oh, my girlfriend, she'll move in and she'll have a place to stay. Well, then now she lives there. And so, yeah, exactly. Can she have a party there? Can she get a new boyfriend? Can that boyfriend move in? What if she gets married, right? Like she meets this guy and they want to get married like in however long. So many different avenues. If you don't have a trust, if you just write this stuff down on a paper and sign it, will that be good enough?
Legal response. It depends, right? The traditional lawyer answer. If you write it down, the question is going to be, is that considered what we call a holographic will, which is an enforceable estate planning document that gets probated through the probate court system and essentially takes the place of a last will and testament? If it doesn't qualify as a holographic will, then what you've left behind are wishes. You've left behind something that could be considered a moral obligation on your child, but not a legal obligation. So in that case, the son could say, fantastic, thank you for these wishes, Dad, but I've inherited the property and I want to liquidate it. I want to sell it, get my inheritance, put it into other investment strategies, and he will have every right to do that.
Right.
So,
and then of course, we talked about this in the first episode, but let's mention it again, the probate word. So regardless, this document, if you don't have a trust, you're going to probate. Remind us the cost. So you have, let's call it a $2 million home, and we're dealing with this in probate. Do you have an idea of what a minimum fee to the courts would be between the lawyers and the courts on a $2 million home?
yeah. So real quick, just a refresher, probate is the court supervised process for the distribution of assets after someone has passed away, if they have a will or if they have no plan. Easy math, $1 million estate, you're paying $23,000 to the attorney, $23,000 to your executor. You're paying court costs and court fees. That's anywhere from $2,000 to $5,000 right now. You're paying your creditors. And then the person who benefits last, or the one you want to benefit most, your loved ones. So $23,000 is what you're paying on a $1 million estate. And then it's pretty easy math after that, 1% over for everything over $1 million. So you've got 23,000. You do the math.
Right. Okay. So is that 23,000 plus the 1%, anything
of the next million.
Right.
Yep. On a $2 million estate.
Let me just clarify something that you said. If you have a will, you're still going to probate.
Yes. A will provides you your great if-then statements. If this happens, then do this, but it doesn't give anyone the authority to step in and act immediately. So we do have to go into probate court to get the judge to approve and appoint someone to act.
Right. Well, I know some people respond to, hey, we're having fun, we're doing trust planning. But folks, I mean, we're doing the opposite. We're doing the fear tactics, right? You're paying thousands and thousands and thousands of dollars, court fees, delays, let me reiterate what you just said. The people that you want to benefit the most are the ones that are actually benefited the last. So there's your call to action. Get an appointment on the books today. Also, Stephanie, I'm going to say this now. I'm going to say this at the end, and I'm going to say this during the next call that we do because it can't be said enough. I have a lot of clients that are 40s, 50s, 60s, their parents. We ask our clients, have they reviewed their parents' trust? And it's one of those taboo subjects like, oh, I think they have one, or I'm sure they have one, or how could they not have one? But, it shocks, it blows the mind how some of the most intelligent people that I know, including clients and family of clients, haven't gone through the process to review their trust, to update their trust, and to make sure that their wishes are actually written down and taken care of in there. So that's your call to action, folks. If you need help with how to have a difficult conversation with your parents, you can talk to me. You can reach out to Stephanie. It is one of the most important things you can do, because if it's too late, then it's too late and you're going to probate. So, Stephanie, by the way, you can help if it's too late for clients, if a family member, a parent of theirs dies, or we're dealing with the children of clients and they die. You represent clients in probate court, correct? You can walk clients through probate.
Absolutely. I definitely do all of the trust administration side, the probate side. So if there's no will, if there's a will, if there's a trust, I can help families navigate through the legal issues associated with an administration, either during incapacity or after death.
Okay. All right. So here's our third situation that we're dealing with here. And this one is the children of the parents are elderly. They're in their 80s. The children are in their 60s. The parents need care. They're living in the home now. One of the kids takes care of the parents. Their primary goal, sorry, let me just back up a little bit. Parents are in their 80s. They're living in the home. There are 3 siblings in this scenario. The siblings want their parents to be able to age in the home, right? Which means that skilled nursing care goes into the home, takes care of them so that they don't have to go to a facility. I think we all learned during COVID-19 that those nursing homes, some of them are great. They're very expensive. Other ones are very problematic and the last place that you want your parents to be. So they want their parents to age in the home. Here's the problem. The parents live in the Bay Area in a $2.5 million home. Congratulations. They have a cost basis on that home of $150,000. Wow, what an investment. Well, besides the minimal Social Security that the parents get, they have no assets. So they're at the situation where they can't pay for the care that they need to stay in the home. So these clients came to me and said, hey, can we do a reverse mortgage? Should we do this? Should we do that? And I'm like, whoa, hold on. Don't start with the thing that you want to do. Let's start with the wishes that you want. So what are some options for having these clients keep their parents in the home so they can age in the house, and that the children can benefit from having the asset passed to them upon the parents being deceased?
Yeah, this is a really difficult situation, and it's something we're seeing a lot more often these days from a planning and administration perspective. Ideally, prior to reaching 80, the ideal scenario is they reach out to their financial advisor and work on getting life insurance with a long-term care rider on it that helps with these out-of-pocket expenses and costs when you get to approaching long-term care solutions. So that would have been the ideal. In the circumstance we're talking about, you've got a couple options. The kids can always help pay for expenses. It's not ideal, but if the kids are really looking to maintain the home, keep parents in it, they can pitch in as far as paying the extras on in-home care that Medi-Cal may not cover. With a home, they may qualify for Medi-Cal now, depending upon their other assets, if they have any other assets, any other bank accounts. But right now, Medi-Cal rules are structured in a way that it's, if you have pretty much any assets at all, you're counted out. You don't qualify. With some exceptions, the home being an exception. If you're living in the home, then you can qualify if you don't have other assets. Good news is future regulations coming down the pipeline, presuming it all runs through the legislative system, everyone will qualify for Medi-Cal in 2024. So historically, we had to do a lot of gifting and transfer of assets, get them out of the parents' names down to the kids right now to get someone qualified for Medi-Cal to be able to start getting states benefits. to help with long-term care costs. In the future, we won't need that gifting strategy. We won't need to deplete an individual's assets to be able to qualify for Medi-Cal. In 2024, we all qualify. How we're going to pay for that as the state, we'll find out. But that's a problem for a later day, right?
Famous last words.
Exactly. Presumably, the way that we're going to help pay for that, everybody qualifies, is what's called Medi-Cal recovery claims. Those come in after individuals have passed away. If they've received Medi-Cal benefits, the estate, the trustee notifies Department of Healthcare Services. And there's a period of time in which DHS can file a Medi-Cal recovery claim against the estate. Right now, under current rules, if you have a trust, and if your assets are in a trust, they're not subject to Medi-Cal recovery claims. Let me say that again. If you have a trust and your assets are titled to a trust, you will not be subject to Medi-Cal recovery claims. Your assets won't be available to DHS to recover. I've seen some instances where the Medi-Cal recovery claim was over $800,000. So that essentially eats up the entire assets of the probate estate. If that estate had been in a trust, if the individual had done trust planning, there would have been no recovery available to DHS for that Medi-Cal claim.
Right. I want to go back to something you said, because in this scenario, there's more equality between the siblings, and they have so long as they have a unified goal of aging the parents in the home, caring for the parents, and having them be there until they, pass away. The home gets the step up in basis, and then the children get to do what they wish with the asset. Right. I love that idea. And that's actually something that I brought up with the client. And they need to be thinking about sharing the burden, the financial responsibility of healthcare, of caring for the parents while they're in the home. So that way they have the ability to hold on to this asset. I like that solution a lot better. It requires the siblings to pitch in, to have a plan together. Is that something that estate planning does, or is that something more so an alignment with, like, how does estate planning and then that goal of, of coordinating care between siblings, how do those two intersect?
Well, estate planning in that perspective is really there to make sure that you minimize administration expenses after death. Since you're going to be incurring a lot of expenses prior to the individual's passing, you want to minimize those expenses thereafter. You want to minimize time after death to get the administration done. And you want to make sure it's spelled out that the estate is going to go equally in this circumstance so that it's straightforward. We get the house distributed, we get it sold, proceeds distributed, because it's going to be a burden on the kids while the parents are still alive. And unfortunately, that's hitting home for a lot of people right now. You're putting out a lot of money to be able to give your parents the lifestyle that they deserve up until their passing, and the care they deserve up until their passing. So what an estate plan can do is minimize the headaches after the fact. Estate planning itself doesn't necessarily help with allocating of costs and everything pre-passing. You can certainly put instructions in there that if, we anticipate the kids are going to be cost sharing potentially. So we want to equalize anything that's unequal after. Right. That can cause some problems. So
Stephanie, I'm just thinking too, if there is an agreement while the parents are alive that, let's say one sibling, let's say there's some discrepancy in how they want the asset to go. So they don't want to sell it and each get a third of the estate. What they actually want to do is two of them want to sell. One of them wants to keep it as a rental property. Right. So, or whatever it is in that regard, the estate plan could say, all right, well, if the siblings agree that maybe one really wants to keep the house and wants to keep the parents aging in there, So say, all right, we'll take the financial burden of paying for the care. And again, life insurance with a long-term care rider or just pure long-term care insurance would really cover that and leverage your dollars. That could be for another discussion another day. Well, then maybe they get 2/3, right, of the home. Because if it's going to be 10 years of care, that could get really expensive. And then so whatever the remnants of that, or maybe your bookkeeping to be able to is that something that you've seen where one of the siblings is going to pay for the care, they're going to keep a record of their expenses, and that dollar amount, whatever that is, would be essentially above and beyond the third. Let's say it's split into third, but one sibling paid for all the care. So they're going to get a third plus the dollar denomination of all that they paid for in care. Is that something you've seen?
Yeah, so that's something you can definitely, if you anticipate that's going to happen, we can write it into the documents that says we know that care may be covered by this child or two of the children, whatever it is. We know that we're going to have help with care. So keep track of that and equalize that before you make the remaining distributions after death. So if one child has spent $120,000 on care or more, then before we distribute the estate equally, we're going to repay that $120,000 to that child to make them whole and then distribute the rest of the estate. And, if there's not cash, if we're still looking at the house, with that $120,000 can be counted as a percentage equity in the home to get that child a little bit more, right? So it's not a third, it's maybe 40% to that child and then the rest to the other two.
Yep. And then 30, 40, one child, 30, the other.
Yep.
So estate planning can take your creativity, the really unique situation that you find yourself and your family in, and codify into law how really that creative solve. And what I want folks at home while you're listening to this to really grasp is that it's hard to do this from a document that you download from the internet. It's hard to do this writing it down and crossing your fingers and hoping that the courts determine that this thing that you scribbled on paper is a holographic will. I mean, there's creativity and freedom that you can have in planning your life and your wishes. You got to do it on the front end. That's what I'm hearing, Stefani.
Absolutely. If you have specific wishes and intent that you want your heirs to follow, your beneficiaries, whoever it may be, you need to get with an attorney. You need to put it in writing. You need to make sure that you have someone else actively conversing with you about, well, what about this circumstance? What about that? Unfortunately, we miss out on that when we do estate planning through the internet, right? You don't have that active voice kind of countering, being a little bit of a devil's advocate for you. And in these situations, when you have these types of instructions you want to leave behind, you need that second voice to help figure out everything that you may not be thinking of.
I love it. Stefani, I think that we gave 3 really great examples today that gave people that are listening some food for thought, some things to think about. I'll close. Well, I'm not going to close just yet, but I want to close with the thought that this creative planning happens with a financial planner because you need a plan in place to make sure that you're making correct financial decisions with assets, with cash flow, and with the proper insurances. And then it needs to happen with the estate planning attorney to make sure that those things are codified into law. All right, we've said it, beat it over the head, boom, we're done. All right, let's talk about this. Stefani, I think this might be one of the most exciting things that we're going to talk about today. And I mentioned it during our first one, but I want to go a little bit deeper. Quiet quitting, launching into the unknown in your career. can be so risky. And I think during the last couple of years, a lot of people have switched up where they work, how they work, when they work. And all that is to say that you made a huge decision, and so did I. I'm a career changer, right? I was an assistant principal of a K-8 bilingual charter school in San Francisco. That's what I did before I was an advisor. Got to the point. Stefani, you were a partner, right, of a law firm here in San Mateo, and you made the decision to launch your own career and go it not alone, but to create a path, to create a business on your own. The first thing I want to say is congratulations again, because you're doing that. But what were some of the things that you were thinking about during that decision? And what are some of the great pieces to the puzzle that you put together to bring you to the conclusion that you needed to launch out and start your own business? Because I think people listening would love to hear about you taking a risk, me taking a risk, and really the rewards on the other side of that.
Yeah. So thank you for the congrats, by the way. It's been really exciting. So I started my own practice. I went solo, as we say, in May of 2021. And it has been the best decision of my life. I loved the firm that I was with in San Mateo. We maintain a really great relationship. I was a partner there for a short time before I left. I still think so highly of them. But when I was looking in the middle of a pandemic, in the middle of worries about visiting my parents and how long I may or may not have left with them, and they are up in Auburn, California, and I was practicing out in the Bay Area. And true, the traffic was fantastic during the pandemic, as in there was none. So I was able to get up often to see them. But evaluating my next life steps, I definitely wanted to move back up to the Sacramento area and get closer to family and friends. That being said, I still maintain a part of my practice out in the Bay Area. So the remote working has really allowed me to broaden my reach and my client reach during this transition. And so that was a huge part. It was allowing me to still maintain client relationships out in the Bay Area through virtual meetings and virtual work that became really highly used and fantastically streamlined during the pandemic. And also being able to move closer to family and friends who can give me a bit of roots to lay some real foundation for my future. So that was a huge deciding factor, as well as the fact that, I was thinking about it one day, and I had always said in the past, I could never start my own practice. I could never do that on my own. I don't know enough. I need the wisdom of older partners and people who have been doing this for 30, 40 years around me constantly. There's no way I could do that on my own. And all of a sudden one day it pinged. It was like that, Coggins Legal. That's exciting. I could do that. I think I could actually pull this off. And, I started thinking about it and doing some budgeting to figure out what the financial side looks like. And it was the first time it's ever been exciting to think about. And I figured, you got to do it when it's exciting. You got to do it when the universe is giving you that push. You've got to trust. So I trusted the push and started and launched my own practice. And it has been so rewarding and so exciting. And I'm still learning how to build it and how to build my clients and my focus, but I still have the 30 and 40 years experienced attorneys. They're colleagues now. They're available when I have questions. I'm still part of study groups, estate planning attorneys. We meet all the time. So I haven't lost that. And, it turns out I can do this. And it's worked. So that's super exciting.
That's great, Stefani. And I think it's obvious for anyone listening that working with you is a pleasure, and you taking a painful subject and make it more fascinating and, dare I say, fun. And I think that launching on your own gives such the message, right? That confidence in what you do, confidence in your own self, and then your desire and your passion and your love for helping clients, right? And get their estate plans in order and get their wishes in place. So just watching you go from the partner in the law firm to launch your own practice. Yeah, we love them too. They're great. And we maintain relationships with different estate planning attorneys because a lot of the time clients come to us with an estate planning attorney already in place. But if they don't have one and we're working together, you are going to be one of the names that I'm going to be introducing my clients to because I think you're fantastic. All right. And I think everybody listening knows that as well. All right. So here's what I need everyone to do. If you're listening and you have questions about, hey, what is financial planning and how does that relate to my estate? Well, then we need to talk, right? We need to talk about what is your strategy for designing income through retirement? What is my strategy of investing? We're dealing with some tumultuous times. What is my strategy to to buy a home in the first place, right? Let alone pass it along later on in life. And what is the strategy to talk to my parents or loved ones or, whatever it is, siblings, in a way that doesn't make them close down, because you can do that, right? Hey, mom, dad, can I see your trust? No, it's none of your business, right? So I think a lot of people are scared to ask those things. We have the skills and we have the experience to give you some of the language and the confidence that you can have those things. The next thing, I know that we talked about this our first episode, Stephanie. Most people do not have an estate plan. Most people think it's just for the ultra wealthy. That's great. Well, don't you want to be wealthy, or don't you want to protect your wealth? If you own a home, you cannot pass that thing down to the next person without a trust. It needs to be titled in the trust. You can't do it unless you go into probate. And Stephanie, gladly you'll take clients that'll go through probate, right? But if you don't want to pay $23,000 plus 1% every dollar above $1 million in the estate, then I recommend that you skip probate. You can just pass it by on the freeway and say, I got my fast pass. I'm going right in the fast zone. So you need to schedule time with Stephanie. What I do for clients is, if it's the first time meeting with Stephanie or another estate planning attorney, then I will be there during the call, because like we've talked about, there's a lot of creative stuff that goes into planning and a lot of questions that you might have never even thought about. So that's the benefit. That's the advantage that we're giving you of speaking to a professional about these things before it's too late. Stephanie, it's been a pleasure having you on the show today. Thank you so much for joining us.
Thank you, Aaron. It's so much fun every time.
All right, Stephanie, how are folks going to reach you?
They can reach me by email, my website, by phone. Website is cogginslegal.com. Email is stephanie@cogginslegal.com. Phone is 916-256-4243. Happy to have a conversation if you have any questions or concerns, or just, want to run something by a planning attorney.
All right. Folks, take advantage of that. You got the information. Now's your time to act. All right. So Stephanie, again, thanks so much for being on our show today, and we'll catch you next time.
Thanks, Aaron.
All right. Aaron Moore is a registered representative with and securities and advisory services offered through LPL Financial, a registered investment advisory member FINRA SIPC. Our guest on today's show, Stefani Coggins and Coggins Legal, are not affiliated with Sagecrest Financial, our firm's new name, nor LPL Financial. The opinions voiced in this show are for general information only and are not intended to provide specific advice or recommendations for any individual. The information is not intended to be a substitute for individualized financial, tax, or legal advice or estate planning advice. Please consult your financial, tax, or legal advisor or estate planning attorney regarding your specific situation. All right, folks, it's been a pleasure. We're going to see you the next time. Take care, everybody.